General law of insurance and brokers. Agencies and brokers. Eventually, the insured agents assured assignments ownership to the investors who receive death benefits when the insured dies. In return, the seniors receive financial incentives. This normally includes an upfront payment, a loan, or a small continuing interest in the policy's death benefit. After the 2-year period, the investors make the premium payments on behalf of the insured. Contracts of insurance are binding and enforceable. As such, all parties to the contract, the insurer and the applicant, are subject to specific legal requirements. We discussed some of the more important regulations that states impose on people who solicit and sell insurance. Next, we focus on the legal aspect of negotiating and issuing contracts of insurance. The law of agency. As noted earlier, an agent is an individual who is authorized by an insurer to sell goods and services on behalf. An agent's role involves the following duties: describing the company's insurance policy to prospective buyers and explaining conditions under which the policies may be obtained, soliciting applicants for insurance, collecting premiums from policyholders, rendering services to prospect and to those who have been purchased policies from the company. Agents and brokers. The authority of an agent to undertake these functions is clearly defined in a contract of the agency or agency agreement between the agent and the company. Within the authority granted, the agent is considered to be the insurance company. The relationship between an agent and the company represented is governed by the agency law. Principle of agency law. By legal definition, an agent is a person who acts for another person or entity known as the principal. For when regarding to contractual agreements, which third party an authorization agent who has the power to bind the principal to contract and the right and responsibility of those contracts. With this in mind, we can review the main principle of agency laws. The act of the agents within the scope of his authority are the acts of the principal. A contract completed by an agent on behalf of the principal is contracting of the principal. Payments made to an agent on behalf of the principal are payments to the principal. Knowledge of the agent regarding business of the principal is presumed to be knowledge of the principal. Agent authority. Agent's authority is another important concept of agency law. Authority is what's given by the insurer to license to translate insurance on the behalf. Technically, only those actions for what an agent is actually authorized can bind a principal. In reality, an agent authority can be quite broad. There are 3 types of agents authorities expressed, implied, and apparent. Let's take a look at each. Express authority. Express authority is the authority, a principal deliberation given to its agent. Express authority is granted by means of the agent's contract, which the principal appointment of the agent to act on its behalf. For example, an agent has the express authority to solicit applicants for the insurance on behalf of the company. Implied authority. Implied authority is the unwritten authority that is not expressed, granted, but when the agent is assumed to have in order to translate the business of principle. Implied authority is incidental expressed authority because it's not every single detail of an agent authority that can spell out in the agent's contract. For example, an agent contract may not be specifically state that he can print business cards on business cards that contain the company's name, but the authority to do so is implied. Apparent authorities is the appearance or assumption of authority based on the actions, words, or deeds of the principal. It can also exist because circumstances the principals create. For example, by providing an individual with a rate book, applicant forms, and sales literature, a company creates the impression that an agency relationship exists between itself and the individual. The company will not later be allowed to deny such a relationship exists. The significance of authority, whether expressed, implied, or apparent, is that it ties the company to the act and deeds of its agency. The law will view the agent and the company as one at the same time when the agents act within the scope of his authority. An insurer may be liable to an insured for unauthorized acts of its agent when the agent contract is unclear about the authorities granted. Agent as a fiduciary. Fiduciary is another legal concept which governs the activity of an agent. A fiduciary is a person who holds a position of financial trust and confidence. Agents act in a fiduciary capacity when they accept premiums on behalf of the insurer or offer advice that affects a personal financial security. Unlike agents, brokers legally represent the insured. A broker or independent agent may represent a number of insurance companies under separate contract agreements. A broker solicits and accepts applications for insurance, and then places the coverage with an insurer. Professional liability insurance, E&O. Just as doctors have malpractice insurance to protect against legal liability arising from professional services, insurance agents need errors and omission E&O, professional liability insurance. Under this insurance, the insurer agrees to pay sums that the agent legally is obtained to pay. Insurance results from professional services that he rendered or failed to render. In addition to the principle of contract in agency law, that are other legal concepts that apply to insurance and the power of agency. These include waiver, estoppel, patrol, evidence, rule, void versus vulnerability, contracts, and fraud. Waiver. A waiver is the voluntarily giving up of a legal given right. If an insurer fails to enforce, waive a provision of a contract, it cannot later deny a claim on a violation of that provision. Estoppel. The concept of wavering and estoppel is close and related. Estoppel is a legal impediment to one party denying the consequence of its own actors or deeds. If such acts or deeds result in another party's acting or in a specific manner, or if certain conclusions are drawn, in other words, if it's the loss of defense. Peril evidence rule. Peril evidence, oral or verbal evidence, or that which is given verbally, is in a court of law. The peril evidence rule states that when parties put their agreements in writing, all provisions verbally state and come together in writing, and a written contract cannot be changed or modified by parole oral evidence. Reasonable expectations. Reasonable expectation is a legal principle that reinforce the rule that ambiguates an insurance contract and should be interpreted in favor of the policy holder. It also states that an insured is entitled to cover under a policy that a sense and prudent person would expect to provide. Void versus vulnerable contract. The term void and vulnerable are often incorrectly used interchangeably. A void contract is so simple an agreement without legal effect. If in effect it is not a contract at all, it's a lack of one of the elements specified by law for a valid contract. A void contract cannot be enforced by either party. For example, a contract of having legal purpose is void, and neither party to the contract can enforce it. An insurer may also void insurance if misrepresentation on the applicant is proven to be material. A voidable contract is a agreement where for a reason satisfactory to the court may be set aside by one of the parties to the contract. It is binding unless the party with the right to reject it wishes to do so. Say that a situation develops under which the policyholder has failed to comply with the conditions of the contract. The policyholder ceased paying the premium. The contract is then voided, and the insurance company has the right to cancel the contract and revoke the coverage. Forms. The insurance carrier is responsible for assembling the policy forms for the insured persons. Fraud. In the event of fraud, insurance contracts are unique in that they run counter to a basic rule of contract. Under most contracts, fraud can be a reason to void contract. When with life insurance contracts, an insurer has only limited period of time, usually 2 years from the date of issue, to challenge the validity of a contract. After that period, the insurer cannot contest the policy or deny or benefits based on material misrepresentation or concealment or fraud.